Hello everyone and welcome to our channel. My name is Gabriela Porto and today I'm going to present you with the legal issues involving the Eastern Karelian opinion, issued by the Permanent Court of International Justice in September 1923. The Eastern Karelian opinion is considered one of the most venerable and enigmatic advisory opinions in international law. It arose from a dispute involving Finland and Russia regarding the status of Eastern Karelia, a Russian province adjacent to Finland. In this opinion, the Permanent Court refused to give its opinions for various reasons that we're going to see next. But before addressing the opinion, I will present you with the dispute's history. Well, it all started back in October 1920, after the First World War, when both states terminated the state of war existing between them with the peace treaty at Dupart. And on the same day, they signed a declaration regarding the autonomy of Eastern Karelia. This declaration gave rise to a dispute involving the signatories of the treaty. Whereas Finland alleged that the declaration possessed the same binding force as the treaty itself, the Soviet government maintained that the instrument created no contractual obligation and merely recorded the state of affairs already existing. So Finland took the matter to the Council of the League of Nations, which adopted a resolution in 1922 to the effect that it was prepared to examine the question, provided that the two interest parties agreed. So the Estonian government invited the Russian to submit a dispute regarding the Eastern Karelian to the examination of the Council, but was met with a refusal. So later on, upon renewing treaties of the Finnish government, the Council decided on April 21, 1923, to adopt a resolution asking the court to give an opinion, asking if Articles 10 and 11 of the Treaty of Peace and the next declaration of the Russian delegation regarding the autonomy of Eastern Karelian constitute engagements of international character which place Russia under an obligation to Finland as to the carrying out of provisions contained therein. So the proceedings began and started with the hearings. The court heard the statements made by the representative of Finnish government. But the Russian government, for its part, informed the court by telegram that it found it impossible to take part in proceedings without legal value either in substance or form, and that it considered it to be a domestic concern. In this context, in July 21, 1923, the court gave its reply to the Council request. It should be noted that both Finland and the Soviet Union, while acknowledging the existence of obligatory force of the treaty, differ as to the interpretation and the legal effect of certain provisions, particularly Articles 10 and 11 that relate to the Eastern Karelian status. Finland understood that it constitutes executory obligations with Russia that it was bound to carry out. And Russia considered that the question was an internal matter and that the declaration was given solely for information. In this context, the court finally issued its opinion and rejected the Council's request for two content reasons. First, due to Russia's lack of consent. The court stated that the questions relate to an actual dispute between Finland and Russia, and since Russia is not a member of the League of Nations, the case is under the Article 19 of the Convent. According to this article, a state which is not a member of the League is invited to accept the obligations of membership for the purpose of such disputes. And if the invitation is accepted, provisions of Articles 12 and 16 may be applied. The rule only accepts and applies a principle which is fundamental of international law, namely the independence of states. And it's well established that no state can be compelled to submit disputes of any kind of pacific settlement without consent. In the present case, however, Russia has never given its consent. On the contrary, the court highlighted that Russia has on several occasions clearly declared that she accepts no intervention by the League of Nations in the disputes of Finland. The court therefore finds it impossible to give an opinion on a dispute of this kind. In addition, the PCIJ also affirmed a second reason for not replying. Because the dispute was actually related to a matter of fact. The court understood that in the present case, it appears doubtful whether there would be available to the court material sufficient to enable it to arrive to any conclusion. The court does not say there is an absolute rule that a request for advisory opinion may not involve some inquiry to the facts, but in ordinary circumstances, it is certainly expedient that the facts upon which the opinion of the court is desired should not be in controversy, as it was in the Eastern Karelian case. Well, it is true that the court is asked for an advisory opinion and not for a judgment. But this circumstance does not essentially modify the court's position. Answering the question would put it substantially equivalent to deciding the very disputes between the parties. The court highlighted that as being a court of justice, it could not, even in giving advisory opinions, depart from the essential rules guiding their activity as a court and not a political tribunal. So that is how the court decided back in 1923. It refused to render an advisory opinion on the disputes where one of the parties rejected any form of international involvement. However, this refusal lasts and has repercussions until today, because it gave rise what is generally referred as the Eastern Karelian Principle, which orthodoxly understood as meaning that state consent is a precondition for the exercise of advisory jurisdiction in bilateral disputes. Whereas the presidential weight of the opinion was also immediately cast in doubt, the Eastern Karelian Principle has been repeatedly invoked before and endorsed by the International Court of Justice, but it has never directly been applied by it. Instead, the principle has been distinguished on increasingly broad grounds, such as in the recent Chagas opinion. But taken as a whole, the Eastern Karelian opinion is considered to be deeply ambiguous regarding the necessity of state consent with regards to the advisory opinion. Recent scholarship suggests that this central ambiguity was not an accident, but rather reflected the fact that the PCIJ was in fact divided. Subjecting the Eastern Karelian opinion to critical analysis means that we can see that, in addition to explicit legal considerations, the court's decisions to reject the request that was also animated by the broader political and institutional questions of the day. In particular, the U.S. accessions and the desire to secure the court's independence from a political league. But after all, can we say the Eastern Karelian Principle is dead? Well, some scholars believe that that any controversial rule of principle, the Eastern Corallian principle is best understood as an assertion of power, a reservation of discretion of the part of the court. While, according to the Orthodox interpretation, the Eastern Corallian principle is understood to be a rule, in reality, is best understood as staking out a margin of discretion for the court to make context-dependent decisions. As much of the court may seek to frame its decision on admissibility in legalistic reasoning, some scholars believe that this question cannot be resolved through a legal epistemology. They affirm that there can be no final synthesis of the Eastern Corallian principles and what it means, because in order to actually play its function of discretionary power, it must be open to contestation. So, if you like this video, please don't hesitate to leave a comment above. Thank you for your attention and see you next week.